Hi everyone and welcome back to the channel. I'm Zoppi, a UK qualified solicitor, and today we'll walk you through how to claim for copyright infringement. This video is broken down into two main sections. Section number 1 will discuss the main principles that are relevant when it comes to copyright infringements. In the second part, I'll walk you through exactly how to claim for copyright infringement in the UK. During that second part, I'll be doing two main things to make things as easy as possible. Number 1, I'll be sharing my screen so you can see exactly what needs to be done. And the second thing is I will link in the description below free documents and resources such as a template letter before action for copyright infringement that you can download so that you have everything you need to complete the process. Okay, let's get started. So first, what is copyright? Copyright is work, artistic work that you've created using your skill or judgment. Now, copyright arises automatically. It's a right that you do not need to register. This is as opposed to, for example, trademarks that you should register with the UK IPO. Copyright infringement, in simple terms, is when someone uses your copyright without your permission. And lastly, letters before action in a copyright claim. Now, the letter before action is a letter that you must use to comply with the pre-action protocol. Now, the pre-action protocol is a procedure, a process that the courts want you to use to try and resolve the issue in an amicable way without having to jump straight into the courts. The reason why is because courts are very lengthy and costly, and they don't want everyone to immediately go to court. Instead, if there are issues that can be resolved outside, then the courts expect you to at least try to do that. Fantastic. So we have a basic understanding of copyright infringement, and the letter before action. Now we can move on to how to actually claim for copyright infringement. So here you should be able to see my screen, and this is a step-by-step guide that I've created for you guys to use. We have 10 main steps, starting with step number 1, which is to collect the evidence of the copyright infringement. Now, to make things as easy as possible, I've created document A, and this is what it looks like, which can help you gather that evidence. Some of the evidence that you might want to gather is evidence of the fact that the copyright is actually yours, evidence of when you produced the copyright, screenshots of the fact that the other party is infringing upon your copyright, and ideally the date of when the infringement occurred. Now, dates are extremely important because we want to be able to show that your copyright was created before the infringing company started using it. Moving on to step number 2, this is just a technical step, and you might want to save the evidence that you gathered in a PDF so that you have all the evidence in the one place. Thirdly, you'll want to draft the letter before action, which is document B. This is what the letter before action template looks like, the square brackets with your particular information. So for example, here you will add your logo and your company's details, the details of the infringing company, and so on. Just to give you a quick outline of how this letter is broken down, there are two main sections to it. The first is the table of defined terms. So on the left column here, you have the term that is used in the body of the letter. And on the right, you will need to include the actual definition for that specific term. So for example, company, you will need to include your company's registered name. The second part of the letter is the actual body of the letter. And this is where we are pretty much telling the infringing company to stop infringing upon your copyright. Then I've added a bonus section, which is referred to as the annex. And these are the undertakings that you request from the infringing company. Now, undertakings are legal promises to do or not do something. So ideally, when you send this letter, the infringing company will return these undertakings to you, having signed them, promising to do or not do something. Now, I've included 8 main promises here, but not all of them will be relevant for you. So what you need to do here is remove any that are not relevant and amend the ones that you keep to make them as specific to you as possible. Fantastic. So after you've done that, you've successfully drafted a letter before action for copyright infringement, and we can move on to step number 4. If you've already amended the undertakings, as we just discussed, fantastic, you've completed this step as well. If not, this is the time to do it. Once you've done that, we can move on to step number 5, which is to attach to the letter a copy of the evidence that you've gathered using document A. So that will be the evidence that you've created as part of step number 2. So you will download, possibly via PDF, the letter that you've drafted, and then combine or attach the evidence that you've gathered in step 2 to that letter. Step number 6 will be to sign and date the letter before action. Now, the date that you put on the letter needs to be the date that you send the letter to the infringing company. So if you sign it and date it today, then you will need to post it today too. Great, we can now move on to step number 7, which is to send the letter before action by signed for first class post using Royal Mail, for example, to the infringing company's registered office address. So I've included 2 links here which are relevant. Number 1 is Royal Mail's website, so you can buy the postage. And the second is the Companies House database, so you can look for the registered office address of the infringing company. Fantastic. So once you've done that, we move on to step number 8, which is to store the tracking code that Royal Mail will have given you. You'll want to keep this in a safe place for future reference because it is strong evidence of the fact that your letter has been successfully delivered to the infringing company, so the infringing company cannot argue that they've not received any letters from you. Step number 9 will be to set a reminder for when you should be hearing back from the infringing company. Now, in the letter that you have drafted, we will have told the infringing company when they should be responding to you. You will have defined this as the response date. Great, we can now move on to step number 10, which is the most unpredictable step because we don't know how the infringing company is going to react to the fact that you've sent them this letter before action. If they respond, then you might want to resolve the issue in an amicable way, for example, via negotiations. If instead they've not responded, which strangely is actually not uncommon in the slightest, then you might have to reach out to an IP litigation or dispute resolution solicitor who might be able to help. If you found this video useful, make sure to subscribe, leave a comment or a like because it really helps with the algorithm. Also, if you have any questions or you would like your letter before action to have more gravitas to make sure that the infringing company, number 1, responds and number 2, actually complies, then reach out to us and we'd be happy to draft the letter for you. I've been Malcolm Zoppi, a UK qualified solicitor and the managing director of Gaffney Zoppi, a boutique corporate and commercial law firm. If you'd like some further help from us, feel free to click on the link in the description and reach out.